Thank you very much, Niradri, and thank you to the JNU students and teachers for inviting me to speak at this on this occasion, the new series on Azaadi. I must also offer you my profound apologies for the delay in my arrival. I believe there were many others who had come and had to leave. I won't give you a story about why and how it took me nearly 10 hours to come from Kolkata to Delhi, because I am told that making any disparaging remarks on the national airline has been declared unconstitutional. So, Azaadi is the topic, and once again I have to commend the students of JNU for restoring to a perfectly good Hindustani word which is used, I think, in every North Indian language, to restore to it its full range of meanings, because in the recent past the word somehow had been reduced to a kind of label, and very often even used pejoratively to mark out people associated especially with the movement in Kashmir. I think it is very important to understand that even that movement and similar movements are part of a much larger set of demands, claims, negotiations that have to do with the broader theme of freedom. And that will be my topic today. So one of the things that we are being told every day now is that freedom is not unlimited, that freedom cannot be absolute. Now this, it seems to me, is a fairly obvious thing. Freedom has never been absolute or unlimited. Everyone knows this. At a very basic level, there are surely natural limits to our freedom to do things. So, I am not free to run like Usain Bolt, even if I wanted to. I cannot be at two places at the same time, right? I cannot jump from the roof and say I will fly to the moon. When I'm sitting here among you at this campus, I'm feeling I wish I had been 25 again. It's not possible. These are natural limits. There are natural limits within which we have to think of what we can or cannot do. But it's important to remember that by acting upon these natural forces, energies, movements, it is possible for human beings to creatively expand their range of freedom. That, in fact, is the very source of creative innovation. From basic things like production to all of the developments of science and engineering, technology and art. That is fundamentally what human beings do, which is act upon the various forces of nature in order to creatively expand the range of things one can do. So I said that, for instance, one cannot be at two places at the same time, or cannot fly to the moon. Even that is possible today, fly to the moon, which is an expression of how freedom could be expanded by creatively using the forces of nature. But more often we tend to think of the question of freedom in terms of social and political constraints. And that will obviously have to be the larger part of our discussion today. Let me begin by saying that these social and political conditions and the way in which freedom is limited by social and political conditions have two different aspects which need to be thought of differently. One is the question of individual freedoms, and the other is collective freedoms. And I will explain why I think we should think of those two things as requiring somewhat different understandings. As far as individual freedoms are concerned, they are limited. They are limited in a lot of ways. Or let's begin, rather than begin from some abstract theoretical propositions, let's begin with the way in which our present social and political setup, broadly defined by, let us say, the Constitution, how that defines individual freedom. We all know Article 19, which gives us the right of freedom to speech, to movement, to residence, to, 3 or 4 different things, right? Each of them is actually limited. Some of these limitations are in the Constitution itself. So for instance, speech, for instance, is specifically limited in the Constitution by specific other provisions. They are also limited by other laws which have been passed by Parliament. But if you think of the broad range, let's think of speech again. It is not as though we are free to speak anything, anywhere, in any setting, in any situation, right? So for instance, what is acceptable speech, let us say in a gathering of young males, would not be acceptable in a mixed country, right? What can be said on the sports field cannot be said in a classroom. We can think of many situations. What can be said in front of elders is different from what can be said among one's own peers. These are specific institutional sites where there are specific conventions, practices, which restrict what is acceptable speech and what is not. We all accept this. In each of these cases, there are authorities which regulate this, which impose this, sometimes even punish. We have all gone through this. Even punish people for inappropriate speech. We should also remember that these conventions or practices undergo change, which obviously means that these practices are often challenged, they are questioned. Over time, we can easily see, for instance, even in our own experience over the last decades, or, for instance, think of what might have been acceptable speech for an upper caste person speaking to a lower caste person maybe 30 years ago, 40 years ago, would not be acceptable today in many public spaces. That is a change. These changes have come about because, of course, conventional practices have been challenged, there have been new claims have been made, and very often the conventions and practices have changed. The crucial thing to remember is that in these kinds of settings or situations, the state is not the agency that regulates, right? What is said, or what can or cannot be said inside a family, what can or cannot be said in a private gathering, what can or cannot be said even in a society, in an association, in a club, even in a public meeting, is not something that is meant to be regulated by the state. Right? Now, the interesting question therefore is, what does the state guarantee? So, think of a situation where, let us say, in a community, where the community elders claim that their conventional social practices prevent young women from going out into town or studying in a college with male students, right? They are trying to impose a certain conventional practice. That practice may come under challenge, right? The question is, if that young woman goes to the state and claims protection of her individual freedom, the state is bound to guarantee and protect that person. In other words, what I'm saying is that in a constitutional democracy, when there is a question of, let us say, freedom of speech, or freedom of movement, freedom of association, any of these freedoms that are guaranteed under Article 19, the default position of the state must always be to protect individual freedom. There may well be exceptions. These exceptions may be negotiated, there may be court rulings, it could be subject to dispute. But as I am saying, the default position must always be that the state protects individual freedoms. If it does not, then really it is no longer a constitutional democracy, it becomes tyranny. There is no other. That is, in fact, the definition of tyranny, where the state does not protect individual freedoms. This will be important in the case of the university, for instance. In fact, I will suggest that in the case of a constitutional democracy, there are two institutions in particular where freedom of speech must have a special protection, must be given special protection. One are bodies of elected representatives, such as parliament, such as the state assemblies. And we all know that, in fact, that is the accepted legal position, that in parliament or in assemblies, what can or cannot be said is regulated by parliament itself or the state assembly itself. Not even the courts can decide. That is understood as parliamentary privilege. I would claim that the university should also have a similar status. It is important because just as the people's representatives are precisely the place where demands and claims and contestations that occur in society at large are in fact put before the state. The parliament or the assembly is the organ of the state which represents the sovereignty of the people. There is no other institution which does. That is the institution which represents the sovereignty of the people. And if that is the case, then in fact, those who have been elected by the people as their representatives must have complete freedom to say what they have to say in that house without any other organ of the state interfering. In the case of the university, the claim would be this, that if freedom of thought and expression is the foundation of any kind of critical and creative thinking in society at large, and this means the entire range of things I mentioned to you earlier on at the very beginning when I said that the creative innovation to expand human freedoms, that depends fundamentally on knowledge, on the ability to use knowledge, to use that knowledge critically, to question existing rules, conventions, institutions. That is the basis on which science progresses, on the basis of which critical thinking progresses, art progresses. And the university is in fact the one institution where this is precisely the job of teachers and students, to promote this kind of critical thinking. As a result, it seems to me one of the absolutely foundational implications of freedom of speech and thought and expression is that the university be completely self-regulated. That is to say, what can or cannot be said in a university, what can or cannot be said in a classroom or a seminar or even a meeting like this, it is the authorities of the university, teachers and students together, who should decide what is acceptable and what is not. Now, everything is not acceptable, we all know this. Even in the classroom, surely there are things that are said which are irrelevant, things that are said which are confused, things that are said which are plain wrong. And of course, it is the duty of whoever is the institution. For instance, if it was in my class, I could certainly tell a student to say, look, this is why you're wrong, you better stop now. We'll move on to something else. But it is the university authorities who best know what is or is not acceptable speech within the university. I think it is completely not only wrong, but even impertinent for state authorities to decide what can or cannot be said in a university. Now, let's move on to one other thing, which is this question of, can speech, any kind of speech, in a university campus, and we can extend that to other arenas of society as well, outside the campus too, be declared seditious. Now, the sedition question, I'm sure you've discussed this many times, I don't have to go into this in detail. The law as it exists is clearly incompatible with any kind of constitutional democracy that is based on the sovereignty of the people. It is simply incompatible. And the reason is this, that the law actually says, it does not say even the state. It says government as established by law. And one understands why it was framed that way in the 1860s when it was first framed. The government at the time, the colonial government, was of course external to the people over whom the government ruled. The government was an outside entity, which is why there was no question, obviously, of representation. The government did not represent the people of India. Now, as a result, it is perfectly understandable why any kind of expression of disloyalty or disaffection would have threatened a colonial government. And therefore, the colonial government could lay down that incredibly broad scope of what is or is not seditious. Even speech is seditious. But that is a law which has continued, and we can, I mean, there are very interesting things about why, for instance, in the 50s and 60s, this law was very seldom used, in fact. And that is obviously because of its association with an entire history of nationalist struggle where virtually every nationalist of any description was at some time or other charged with sedition. So in the 50s and 60s, it was in fact rarely used. It began to be used once more from the 70s. And in recent times, it has become rampant, even though the courts have repeatedly said that there must be a distinction between advocacy and incitement. Right? The courts have never quite gone to the extent of saying it is unconstitutional, although some of the judgments almost seem to go that far. But they haven't. What they have said is that mere speech and even advocacy cannot mean sedition. You have to show the actual imminent threat of harm or injury to the state. Now, we all know that many of these cases, these sedition cases, don't actually stand up in court, but it is a widespread, there is a widespread use of that act to harass, intimidate, and threaten people. According to that law, any kind of opposition to government, and remember, the government means any government elected by the people, right? The government of the day. Any statement that is deemed to be critical or claiming disaffection or inciting, not inciting, advocating disaffection towards the government of the day, which means any kind of opposition to the government, can be declared seditious. It is, I think, an act which certainly must go. That is a claim that needs to be made repeatedly. Let me now move on to from individual freedoms to something like collective Azaadi. Okay? And let me begin by saying that this understanding of a collective notion of freedom or Azaadi, something that pertains to an entire group, is actually difficult to make. It's difficult to contain within a strictly liberal understanding of the Constitution. Because, as we all know, the liberal understanding is fundamentally based on a notion of individual freedoms. So a collective freedom is always difficult to formulate in strictly liberal terms. But there are certain kinds of collective rights that historically have been recognized, even within liberal constitutional systems. And the most obvious one is the question of national self-government or self-determination. Now, this has happened, of course, through an entire history of anti-imperial and anti-colonial struggles, that this right has been accepted to the extent that the United Nations, for instance, this is one of the declarations that part of the history of the founding of the United Nations, the right of all peoples and nations to self-determination. But when one thinks of collective freedoms, I think it is important to understand that it rests on something, and this is slightly different, which is why I was saying that individual freedoms and collective freedoms, Azaadi in the individual and collective sense, have to be thought of somewhat differently. Because in the collective sense, it actually depends on a certain relationship of an oppressed side and an oppressor side. If you think through this idea of collective freedoms, you will find that in every case, the claim to some collective right to autonomy is based on a perception that there is an oppressor who is holding a particular group in subjection. That is what is contested, resisted, and that is the foundation of a claim to self-rule or autonomy or self-determination. If you think of the history of anti-colonial nationalism, this becomes obvious. That anti-colonial nationalism basically is founded on the idea that there are oppressor nations and oppressed nations. And it is the right of the oppressed nation to claim self-determination or independence from the oppressor nation. We all know that through the history of the anti-colonial movements, this right of national self-determination has been, by the, let's say, the second half of the 20th century, this right was more or less universally established. But it's important to remember that this right was established in a way that had two very specific characteristics. First of all, it was a resolution that was territorial. The national self-determination or national autonomy was always conceived of as a claim over a particular territory with clear boundaries. There's a whole history to be described here of how this idea of nations as having territorial boundaries emerged in Europe, through maybe from the 17th century onwards, and was carried on to the rest of the world through the colonial empires, in fact, where the colonial empires between themselves drew boundaries to define which part of the world belongs to which colonial power. Some of you may know of the infamous Berlin Conference of 1885, where basically on a drawing board, the various imperial powers sat down and divided up Africa. One of the peculiar things you will notice if you look at the map of Africa is that most of the boundaries are along longitudes and latitudes. They're simply drawn on a map, right? And divided up. This is French, this is Portuguese, this is British, etc. Now, so the territorial jurisdiction, a unique sovereignty over a territory, is the first characteristic. And the second characteristic is the claim, and this of course is a more recent claim, this is the success of the anti-colonial movements, to claim that all sovereignties are formally equal. Which explains why in the General Assembly of the United Nations, every member state, irrespective of whether it is large or small, has exactly one vote, which signifies the formal equality of all nations, the sovereignty of all nations. Now, the reason I explain this is because if you then look at how collective claims are negotiated within the boundaries of a nation, you will find that in fact the same structure is replicated. So for instance, think of countries where there are separate units that together form a federation. So there are many federal countries in the world, including India. The degree of federation, how much the sovereignty is divided up, what is the proportion in which power is divided, between a central government and the various state or provincial governments, that varies. But if you again look at why there are claims that there should be a separate federal unit, why does it come up? You will find that it is once again the same claim of an oppressed side and an oppressor side. If we look at the history of the Indian state or the Indian Federation from the time of independence, and you look at the various claims that have been made over time, some of you may have read about the anti-Hindi agitation in the Tamil areas in Madras, right, led by Periyar, where in fact a specific claim was made that the Tamil-speaking parts should secede from India. It was a claim that was made at the time. And of course, both the Congress in Madras as well as the rest of many sections of opinion, the rest of India thought this was a threat to national unity itself. Now, the interesting thing to note is that claims like this and their resolution are never permanent. There is never a permanent claim, nor is there a permanent settlement. The Tamil case is interesting because, of course, that movement of the early 1950s, we now know, later became completely incorporated within the framework of constitutional electoral democracy in the form of the, well, now the two main Dravida parties, which are inheritors of Tamil nationalism, but no longer considered a threat to national unity. Think of the Andhra movement, 1954, demanding a separate state for the Telugu-speaking regions, which of course then led to the entire demand for reorganizing all of the provinces of India into linguistic states, the States Reorganization Commission. By 56, most of the states began this process of redrawing the boundaries of the states according to linguistic regions. Even Nehru was opposed to